By the time the courtroom doors opened, the story was already finished. Not resolved, not understood. Finished. The decisions that mattered had been made in private rooms, on quiet days, by people who believed no one would ever ask why. The courtroom was not there to uncover the truth. It was there to decide which version of it would survive. Inside, there were no family stories, no promises, no explanations, only paper, ink laid down months earlier, signatures written by hands that no longer trembled, dates that could not be moved. Whatever happened next would not restore what had been lost. It would only determine who controlled what remained. This was not a fight between relatives. It was a fight between a trust and a man and his daughter. And once it reached this room, there was no way back. What followed was not rumor or recollection or family memory. It was a lawsuit. It is worth noting where the will first surfaced. Maryland Orphans Court. That's because the Orphans Court typically handled probate cases. A court created not to resolve disputes between equals, but to protect those who could not protect themselves. And while the name may sound antiquated now, in its time it carried a clear meaning. Someone, somewhere, was supposed to be looking out for someone else. In early 1951, the trustee of the estate took the extraordinary step of asking a judge to decide the issues that private documents could no longer resolve. It appears in the federal record as Washington Loan and Trust Company versus Lyon, filed in Washington, D.C. at the federal level. This was not a dispute over a single clause. It was a challenge to control itself. To whom did the authority to act for the dead belong? And whether the structure put in place after Irene's death could survive being examined in public. This is how, 4 years after the headlines of about her husband's suicide, Betsy Lyon found herself back in the headlines. The Washington Times-Herald offered a photo of her and focused the headlines on her with the title, "Daughter Renews Legal Fight to Overturn Mrs. Lyon's Will." She looks wiser, arguably wearier than what the Parade magazine photograph otherwise intimated. Betsy faces the camera directly. Her posture is upright, composed. Her hair is dark and neatly styled, parted and pulled back from her face, held in place with a simple band or scarf that disappears into the shadow behind her head. It gives the impression of order and intention. Nothing is out of place. Her features are symmetrical and calm. The eyes are steady, looking straight ahead, not down, not away. The mouth is set, lips closed, offering no hint of emotion beyond resolve. She wears a tailored jacket over a light blouse, conservative and appropriate for the era. It signals respectability, seriousness, and an understanding of how one is expected to appear in public. It is the kind of image used when a person has become part of a public record rather than a private life, a face that is already recognized. Below the photograph, the caption reads simply, Mrs. Kelly. Just the title and a surname that differs from the estate name in question. Would she be able to shape the media narrative once again? Importantly, in the revision to Irene Moore, Lyon's updated trust, only the interest income was to go to her daughter. But what about the principal of the $700,000 estate? The magnificent principal, worth about $9 to $10 million in today's money, was to be held in trust for Mrs. Kelly's child, Freddie, until after Betsy's death. The same child that tragically lost a father to suicide just 4 years earlier. According to newspaper records, the estate also included 5 automobiles, valued at $5,000 each, household furnishings of $15,000, a collection of jewelry of an undisclosed value. And there was, of course, the 119-acre estate. Betsy would be fine, but if the will were not to be reversed, she would have to live a comparatively meager life. Living off the interest is spending what the estate produces. Living off the principal is spending the estate itself. Once the principal is spent, there is no longer a trust, only a memory of one. It seems Irene Moore, rightfully, had a soft spot for her grandson, Freddie, who had only letters from his father's grave to show at this point. In the early proceedings in January of 1950, Mrs. Kelly, our Betsy, failed in an initial attempt to break the bank's control of the estate. In another suit, Dr. Lyon was working to utilize a Maryland property law that laid his claim to at least 1/3 of the estate. Father and daughter were working independently, using allegations of fraud and incapacity in the filings to leverage their claims. They claimed Irene was not of sound and disposing mind when the will was rewritten. However, they were getting nowhere fast. According to a November 27, 1951 article, Mrs. Kelly lost a lawsuit to require the Washington Loan and Trust Company to turn over to her about $10,000 from the trust fund set up for her in her mother's will, a relatively small amount given the overall money at stake. And then the court case took a turn. The litigants charged that they were unable to get a fair trial in Montgomery County and successfully obtained a transfer of the case to a new location. At first glance, a change in venue from Montgomery County to Prince George's County can look administrative, a matter of jurisdiction, a filing detail. But in estate litigation, venue is never neutral. In the mid-20th century, those differences were felt even more strongly than they are today. Prince George's County was larger and faster moving than Montgomery County. It had a more institutional court culture, was accustomed to trust and estate matters involving banks, professionals, and complex filings, and focused more on documents than on local memory. In a court like Prince George's County, authority mattered more than attention. Professional standing and familiarity with fiduciary roles carried weight. The quiet confidence of someone already entrusted with responsibility would be key. Dr. Lyon did not need to explain who he was. The structure itself did that for him. Publicity, by contrast, offered no advantage here. Headlines did not sway judges. Photographs, no matter how appealing, would not alter trust language. And whatever influence attention may have had elsewhere, it stopped at the courtroom door. And Betsy's media presence likely did nothing to help in that particular room, because courts like that one were designed to be immune to it. As such, and galvanized by less than productive proceedings up until this point, the father and daughter would begin working together. They had so much to lose, and so much to gain. Although it's certain they had their own conflicts, Betsy recalled, under oath, a December 1948 occasion where she had her father arrested on assault and battery charges. She later withdrew the charges after Dr. Lyon was locked up overnight. Amongst other compelling testimony, one of the elements that supported the assertion of Irene Moore's mental capacity involved damning words from the son-in-law, Harry Kelly, who helped run the estate. According to a November 27, 1951 article, Mr. Kelly testified that in July of 1949, with the outside temperature at a scorching 96 degrees, Irene Moore Lyon had asked that a fire be built in one of the fireplaces. Harry counseled with his wife, our Betsy. Betsy called their lawyer and reported back to Harry that the lawyer advised the following: if she, Irene, wants a fire, let her have a fire. The fire was built only to have Irene Moore Lyon almost immediately declare that it was too hot for a fire. She then ordered Harry Kelly to put out the fire. At least 35 witnesses took the stand over the entirety of the trial. Among many compelling conversations, a key component of the case occurred when doctors described 2 cerebral hemorrhages that left Irene Moore's entire left side paralyzed. They stated, for the record, her mind was impaired. It took the jury of 6 men and 6 women only 53 minutes to return. The resolution to our case is best reported in my details, found on the front page of the December 6, 1951 Washington Times-Herald. The headline read, $750,000, Lyon will broken, by Maryland jury. All caps, fully justified. Then in 2 smaller headlines, woman's mind held unsound at PG trial. The paper had highlighted the shift in jurisdictional power, followed by a smaller notation, bank is removed as trustee. As the story detailed, the bulk of the estate was to now be returned. Dr. Lyon and Betsy had won. And while we're able to come to a conclusion with regard to the contested will, what was already in motion would not completely end with this ruling. It would echo and reverberate in later filings and in additional disputes. There's but one more story to tell in our next episode, Aftermath.